Hi, and welcome to Holland Estate and Succession Planning. You're listening to episode 143 of our podcast on Tuesday, December 16th, 2008. Hi there, Ian.
Hi, Susanna.
It's good to have you back. We had the pleasure of your dad having been joining me on the last two podcasts, but it's always good to go back to the starting ground.
It's nice to be back.
Just a quick reminder to any of our listeners who have any comments, would like to provide us with feedback, to please feel free to send us an email at hullandhull@gmail.com.
And please feel free to look at our blog, estatelaw@hullandhull.com. It goes up daily, and we always appreciate feedback. All right, Susanna, today we are enjoying the pleasures of early adopters into technology because this is our second take. We're going to be launching it hopefully today on time, but we had a good discussion, unfortunately it wasn't recorded, about the use of and the impact of trust companies in estate planning, and how the pros and the cons a little bit, and how they can be used in an efficient way in terms of general estate planning, and then also how they're used in some of the contentious situations. So why don't we start with first of all, start at the beginning. What, if any, purpose would a trust company serve in dealing with them in an estate planning context?
Well, I think, Ian, we can distinguish between dealing with them as executors or estate trustees of an estate, so that when they're involved after someone has passed away, and dealing with and including a trust company in your planning while you're still alive for a power of attorney, either as property power of attorney or personal care power of attorney, or if you take it one step further and you haven't got the power of attorney in place, then in a guardianship proceeding when they can be guardians of property or personal care.
Okay, so those are the two sort of core sources where we see them. And I would say maybe subcategories of that are some of their sort of typical roles. One is that they will actively be involved in investment management. And another is how they're involved with an agency relationship. And what are we getting at with that?
And you're suggesting, Ian, when they're working in an arrangement where there's corporations perhaps involved in an estate, or when they're doing pieces of work as opposed to the whole puzzle? Is that what you're suggesting?
Absolutely. And somehow, sometimes we get into situations, even on straightforward estates, where the individual doesn't really want to do the paperwork. So you hire the trust company to do the paperwork.
That's right.
So to speak. They're the administrative wing of the administration of the assets. So, sorry, yeah.
And I guess the advantage of that is the fact that the trust companies really know what's required at the end of the day when they do have to account for their work as fiduciaries. And we've talked in previous podcasts about that obligation to account and to keep beneficiaries informed. And so they probably have that down to a fine art, better than the average person would, who would have to have the same kind of obligations.
Absolutely. All right, so let's focus a little bit now on the conventional role of the trustee. Now, first of all, the role of a trustee by a trust company can be useful when you have a large estate, because you don't have to worry about, I guess, really the financial backing behind it. You can maybe set up a situation where you have a large estate. You may want to have a parent or your spouse and a trust company, and it works with large and small. And one of the myths that we probably should debunk at the start of this is that trust companies aren't typically any more or any less expensive than people.
And we've talked in the past about the fact that there's the rule of thumb that an executor would probably be entitled to about 5% of the value of an estate when it comes to compensation. And so you're suggesting that it would be the same for a trust company, or if it's a trust company working in conjunction with someone else, that still it would be the same total entitlement?
And yeah, and we can typically get into arrangements and negotiate with them, and it's always best to negotiate with them while you're alive. So you can set up a situation where maybe you want to share it or you don't want to share it, but maybe you can get a bit of a better deal when you promise them the job, enter into some sort of agreement, that enforceable agreement that compels them to act on those parameters. They may not take the job on when you die, but at least you've got some certainty, and look for a reduction of the general rule of thumb in terms of pricing. So that can be useful at any range, big or small estates.
But presumably it would be more enticing to them to offer a reduced rate on a much larger estate.
That tends to be the case. But even in modest estates that you can have a fairly straightforward administration, there can be some money to be made for them. And what happens then, Susanna, on getting paid for being an executor when you have, for example, a trust company who is a true co-executor with the surviving spouse? How does the fee get split?
And that usually, Ian, comes about as a result of the negotiations between the two executors, because at their highest, they're entitled to that total amount, whether it's 5% as a general rule or whatever it is that has been agreed to prior to the job being taken by everyone. And so it's a matter of just allocating that. And normally that'll come down to a reasonable allocation as to, who's done the primary bulk of the work and who should be entitled to the compensation and how that's split. It doesn't have to be equal. It could be 1/3, it could be a quarter, it could be whatever, but it's something that is definitely negotiated between the parties.
All right, so now that we've got that scenario in a conventional estate environment, what are some of the business reasons for getting a trust company involved, as opposed to notwithstanding the fact you can get a better deal? What are some of the business reasons?
Well, the truth is, Ian, the job of an executor is a very demanding one. The obligations as a fiduciary are quite high. The accounting alone, having to account for every single dollar that comes into an estate and out of an estate, it can be a tremendous undertaking for someone who has a day job, for instance, in addition to being an executor. Oftentimes, the estates can be quite complex when you've got a corporation that's involved or other corporate assets, and so someone at some point will have to deal with the fact that there is this asset that has to be taken care of. Someone's got to step in to make sure that it's properly being run, that it's being controlled. And oftentimes, the trust companies have that expertise that an average person wouldn't necessarily have, that can make that a much more, I'd say, business-like decision.
I also find, too, that trust companies are good at resourcing out problems, even in every range of estate. Even, it always surprises me that it's not just the wealthy who get into complex tax problems, or it's not just the wealthy who get into complex business and accounting issues. And the trust companies tend to have the resources at their fingertips. They've used these people before, for an example, if you need a sophisticated tax advice, or if you need sophisticated corporate advice. They have the access and the tried, tested, and true resources. So it's sort of part and parcel of the package that comes with it.
And I think the one thing that I also hear clients often say is that when you can't choose between two family members, or you know that that's going to be a problem down the line, it might be better to just consider this neutral third party who's going to come in and do the job for you. And so there won't be that, there's the possibility of avoiding that, the end run by the beneficiaries at the end of the day against the named executor.
And you see it more and more, too, in the context of powers of attorney for that same reason. That if you don't want to have a fight over who's going to manage mom and dad's or mom or dad's money as they move into their elder years, putting a neutral third-party trust company in to manage money even before death can be a good idea to keep sort of the affairs of the money in the family at business level, as opposed to a personal level. And
there's a lot of continuity too that can come from that, because if you've got someone who's a third party in there administering during lifetime, then once they pass away, the executor is going to pick up the value of the estate based on what the attorney has determined it to be, and that really helps with the transition as well.
And getting back to the pricing, can't hurt that you go to the trust company, right? And you say, listen, I'd like you to be my power of attorney for property, and I'd also like you to be my executor. Let's talk fees. So really, from that standpoint alone, you've got some flexibility, you've got professionalism, you've got possibly reduced costs, which is always a surprise to people when they really look at this situation, because they presume quite frankly wrongly, that the trust company is a bugaboo on that front. And I think that more and more, certainly, with estates being more complicated than even anyone can imagine, it's always good to bring the expertise and the professionalism in. For example, more than that, 10 years ago, nobody worried about RESPs, and registered retirement savings plans were the simple thing, and now you get into college plans and things like that, and that's just an example of something that even can be a modest asset that can affect some complexities that you can get a professional in. So we've, I think, quite appropriately had a good discussion about the trust companies and how they can play a role in both modest and significant estate planning, and in between estate planning.
And so I think that brings us to the end of this podcast, Ian. Just a quick reminder to our listeners to feel free to provide us with any feedback they may have at hullandhull@gmail.com.
And please welcome you to come to our blog. Daily, comes up Monday to Friday, almost always, subject to technical difficulties, at estatelaw@hullandhull.com. Thank you.
You have been listening to Hull and Estate and Succession Planning by Ian Hull and Suzana-Popovic Montag. The podcast you have been listening to has provided as an information service and is a summary of current issues in estates and estate planning. It is not legal advice, and you're reminded to always speak with a legal professional regarding your specific circumstance. To listen to other Hull and Hull podcasts or leave any questions or comments, please visit our website at hullestatemediation.com.